and relative care can be an obstacle course, but with the right guide, a caregiver can successfully cross the finish line. This training drill will help you go over, under, and through any obstacle you'll find along the way. Welcome to the Foster and Relative Caregiver Training Drill on Timelines and Reasonable Efforts. This should take you approximately 30 minutes to complete and is approved for 30 minutes of training hours. Be sure to print the completion form before you begin this video. You will need this form to answer your checkpoint quiz questions as we progress through the training. If you're ready, here we go!
Hello, and welcome to the training for foster parents on timelines and reasonable efforts in juvenile court cases. Today we'll be talking about the juvenile court process and the timelines for that process, reasonable efforts required to be made by DFS, and then subsequent legal actions that may occur after the juvenile court case and the timelines for those, the courts that they're filed in, and who files them. If you have any questions during or after this presentation, be sure and ask your foster care coordinator, and we thank you for your interest in these trainings. We're going to start out talking about the general juvenile court process and timelines. In general, juvenile court is a civil court for children and families when there's abuse, neglect, CHINS, which is a child in need of supervision, or a delinquency issue at case. Other cases like a termination of parental rights case or guardianship are filed in civil district court. These are actually the same courtrooms and the same judges who wear different hats on different days. So although you'll be going to the same court for those different proceedings, you must know that juvenile court cases are very different. In juvenile court, the judge can require the child and family to submit to evaluations and get services for things such as drug treatment, parenting, education, mental health services, and counseling. In addition, if the home is not safe for the child, or if the child is not safe to be in the home or community, the child can be placed outside of the home by the judge in something like foster care, kinship care, juvenile detention, a juvenile treatment facility, therapeutic foster care, etc. The main difference between juvenile court and other civil district court proceedings are that they're closed and confidential, which means that the public cannot watch the proceedings and people cannot come in to see what's going on. The court can also exclude any witnesses or extended family from viewing the proceedings if it's uncomfortable for the client or uncomfortable for a parent.
So you've learned about juvenile court proceedings. Let's take a quick quiz on what we've discussed so far. Complete the following thought. Juvenile court is A, civil court, B, a closed court, C, a confidential court, or is it D, all of the above? Please take a few moments to think about your answer. If you answered D, all of the above, then you are correct. Juvenile court is a civil court, not criminal, and the proceedings are closed and confidential. Remember that it is held in the same courtrooms and often with the same judges as district court, but the rules are different and the process is unique.
A juvenile court case starts in one of three ways. First is with protective custody being taken. This can occur in an abuse-neglect case and also in a CHINS case, where law enforcement or medical personnel takes temporary protective custody to protect the safety of a child that is in imminent danger. The second way is with a petition being filed. The county or district attorney can actually file a petition to start both an abuse-neglect case and a CHINS case without protective custody being taken. And the third way, in a delinquency case, begins with the juvenile being cited and then being petitioned by the county or district attorney into juvenile court. In general, all three types of juvenile court cases, abuse, neglect, CHINS, and delinquency cases, follow the same court process that I'm going to talk about briefly here and in more detail as we go on today. As I said before, first you're either going to have protective custody taken or a petition that's filed, and that's going to begin the court process. Then you're going to have a shelter care hearing or a detention hearing if the child was taken into protective custody or put in detention in a delinquency case. Then you'll have an initial hearing. Sometimes that initial hearing is held at the same time as the shelter care hearing. And if you don't have protective custody or detention taken, you won't have a shelter care or detention hearing, and you'll just begin with an initial hearing. After that, you'll have an adjudicatory hearing or a trial, but you can also have a consent decree, which would then skip over the adjudicatory hearing or trial. After that, you'll have a dispositional hearing, and then every 6 months from the time the child was taken into care, you'll have a review hearing, and every 12 months from the time the child was taken into care, you'll have a permanency hearing. During that time, you'll also have MDT, multidisciplinary meetings. And then, as we'll talk about a bit more later, you can have subsequent legal actions that occur out of the juvenile court process, which are not in juvenile court and are separate proceedings, but are directly related to that court case. First, you can have an appeal to the Supreme Court, and you can have that from the juvenile court case or the termination of parental rights case. You can have a termination of parental rights case, you can have a guardianship case, or an adoption case. Once a case comes to the attention of the Department of Family Services, they are required to investigate any reports made to them of abuse or neglect. So they're going to receive, assess, or investigate all reports of known or suspected child abuse or neglect. They have to initiate this investigation or assessment within 24 hours after receiving the report. They have to advise the alleged perpetrator of the specific complaint the first time that they have contact with them, and then conduct a thorough investigation pursuant to their rules and policies. This investigation may or may not lead to a neglect petition in juvenile court. A person can actually be substantiated for child abuse and neglect and put on the central registry without being adjudicated in court. And there are actually 2 tracks, which we're going to talk about in a minute, that DFS will go on: an investigation track, which will be seen in juvenile court, and an assessment track, which doesn't see the inside of the courtroom. After they find that abuse or neglect is present, then DFS is required to initiate services for that family to address the abuse and neglect that is there. So the 2 tracks that DFS can take, as I said, are investigation and assessment. And this is decided at intake, which means when the DFS worker gets the initial report, they have to look at the situation in the report and decide these things. So if a child in the report appears to be in imminent danger, if criminal charges could be filed, so not that they're going to be filed, but if they could be filed, and remember, this is in the mind of the DFS worker, not law enforcement or an attorney, and it's likely that the child will be needed to be removed from the home, then that case must go into an investigation track. If it involves a major injury, it has to go into an investigation track. If it involves sexual abuse, it has to go into investigation. And finally, if it involves a child fatality, then it'll go into the investigation track. The statute says that any other reports will go into the assessment track.
So you've learned about DFS's investigation of reports. Let's take a quick quiz on what we've discussed so far. Which type of abuse-neglect reports must be handled by DFS through the investigation track? Is it A, educational neglect, B, medical neglect, C, sexual abuse, or D, lack of supervision neglect? Please take a few moments to think about your answer. If you chose C, sexual abuse, then you are correct. Wyoming statutes require reports of sexual abuse to go through the investigation track at the Department of Family Services. The other three types of cases are not specifically listed in the statute as an investigative track case, but may become one if criminal charges can be filed, the child appears in imminent danger, and it is likely the child will be removed from the home.
Temporary protective custody can be taken if there are reasonable grounds to believe that a child is abandoned, lost, suffering from illness or injury, or seriously endangered by his surroundings, or if the child's conduct or behavior seriously endangers himself. DFS cannot take protective custody. It can only be taken by a physician, a physician's assistant, a nurse practitioner, or law enforcement. The person that's taking protective custody of the child then immediately notifies DFS, and then DFS accepts physical custody of the child for placement in foster care or kinship care. The actual start of a neglect proceeding or any other court proceeding is the district or county attorney determining if the child's best interests require judicial action, and starts with the filing of that petition, which we called a verified petition. If protective custody has been taken, then they must have the shelter care hearing within 48 hours, but this excludes weekends and holidays, which is why sometimes it can take longer. If there's no protective custody taken, then there is no shelter care hearing held, and the court process goes directly to the initial hearing.
So you learned about temporary protective custody. Let's take a quick quiz on what we've discussed so far. True or false? The Department of Family Services can take protective custody of a child that is in imminent danger, meaning there are reasonable grounds to believe a child is abandoned, lost, suffering from illness or injury, or seriously endangered by his surroundings, or the child's conduct or behavior seriously endangers himself. If you answered false, you are correct. Protective custody cannot be taken by the Department of Family Services. They only accept physical custody of the child once protective custody is taken. The only individuals that can take protective custody are physicians, physician's assistant, nurse practitioners, or law enforcement officers.
Although the general timeline of a juvenile court proceeding can vary, there are some specific timelines set out in the statute for juvenile court proceedings. In abuse and neglect cases, if protective custody has been taken, as we stated before, a shelter care hearing must be held within 48 hours. Also, an adjudicatory hearing must be held within 90 days of the initial hearing, and a dispositional hearing must be held within 60 days of an adjudication. If a child is in out-of-home placement, not living with their family, then the court has to hold review hearings every 6 months and MDT meetings every 3 months. Finally, within 12 months from the out-of-home placement, the court must hold a permanency hearing. You may hear, as you work in these cases, people talk about 15 of 22 and a clock that's ticking, or the 15 of 22 timeline. This comes from ASFA, which is a federal law called Adoption and Safe Families Act. This is also in the state statute. And what it says is if a child has been in out-of-home placement for 15 of the last 22 months, then the state must move towards termination of parental rights. This means that if a child is out of home and then goes home for a trial home placement that doesn't work and goes back into out-of-home placement, that time will not count and will count towards the 15 of the last 22 months. Because every child and every family is different, and every situation that we're dealing with in juvenile court can be very different, juvenile court cases and their overall length of time vary very much. Some cases will be over in as little as 3 months, and others can last 3 years or even more. Generally, the goal is to provide the services and get the child back in the home in 1 year, to stay within the 15 of 22 timeline from ASFA and state statute. But as you'll find, some situations and families can take more time. For example, a drug addiction can take more time to deal with than 12 months.
So you've learned about juvenile court timelines. Let's take a quick quiz on what we've discussed so far. Although the general timeline of a juvenile court proceeding can differ, the following timelines are set out in the statute for abuse-neglect proceedings. Is it A, a case should take less than 12 months? B, a case can take more than 3 years? C, all of the above? Or is it D, none of the above? Please take a moment to think about your answer. If you answered D, none of the above, then you are correct. Although a case can be completed in as few as 3 months or as long as 3 years, and typically can take around 12 months to reunify, it is important to remember that these are general guidelines that are not set out by statute. The only timelines that are set out by statute are the hours, days, and months between hearings.
Next, we're going to talk a little bit about reasonable efforts. So during the pendency of the juvenile court case and the timelines we've just discussed, DFS is busy providing reasonable efforts to reunify the family. Let's talk about exactly what reasonable efforts are. Federal and state laws require the department to provide reasonable efforts to prevent removal of a child from their home, to reunify the child with the parents, and to effect permanency for the child. These efforts are less of a prescribed set of actions and more of a general concept. There's no defined set of tasks or services that DFS must provide to the family in order to meet reasonable efforts, and there shouldn't be, because no family and no situation is the same. It's more of a mindset that the worker has met the needs of the family and provided the services needed to get the child back in the home. The final issue we're going to talk about today are the 4 different types of legal actions that can be filed subsequent to a juvenile court action and their corresponding timelines. Please keep in mind that all of the timelines provided to you today, both before talking about subsequent legal actions and after, are general guidelines, and that's all. Each case, each court, and each judge can have different timelines for finishing cases in juvenile court, district court, and Supreme Court. The first case we're going to talk about is a Supreme Court appeal. This can be filed by any party in the juvenile court action or any party in the termination of parental rights action. It's filed in the Wyoming Supreme Court, not in the juvenile or district court, and the general timeline is 3 to 12 months. This is figured out by looking at after a case is docketed, an appellant usually has 30 days to file their brief. The appellee then has 30 days to file their brief, and then the appellant has 15 days to file their reply brief. Then the parties can wait approximately 1 to 9 months for oral arguments to be set, oral arguments to be made, and then a decision from the court. The second potential case is a guardianship case. This is filed by DFS represented by the Attorney General's office and is filed in district court, which once again is the same court and judge as juvenile court, but it's not the closed confidential juvenile court proceeding and is not in the same juvenile court proceeding below the guardianship case. The general timeline is 3 to 18 months. This depends very much on whether or not it is a voluntary guardianship or a contested guardianship. A voluntary guardianship is one that the parents have agreed to and signed a paper that says that they agree that the child should be in a guardianship with the guardians. A contested guardianship is one where they do not agree and the court has to have a contested hearing on whether or not to put the guardianship in place. The third type of case is a termination of parental rights. This is filed by the county or district attorney or the Attorney General's office on behalf of the county or district attorney. It's filed in district court, not in juvenile court, and the general timeline is 3 to 18 months. This can depend greatly on court dockets, availability of parties and counsel for a contested hearing, and whether or not it's a default hearing. The final case is an adoption. This is filed by the proposed adoptive parents. Outside of the juvenile court case, it is also in district court, and the timeline can be 1 to 8 months depending on the length of time the child's been in the home and how quickly the paperwork can be put together by both DFS and the prospective adoptive parents' attorneys.
So you've learned about potential legal actions. Let's take a quick quiz on what we've discussed so far. How many potential subsequent legal actions can arise from a juvenile court proceeding? Please choose one of the following: 4, 3, 2, or 1. Take a moment to think about your answer. If you answered A, 4, then you are correct. There are 4 potential subsequent legal actions that can arise from a juvenile court proceeding: Supreme Court appeal, a guardianship, a termination of parental rights, and adoption. Although some cases will not have any subsequent legal actions, and not all of these actions will be filed in every case. Congratulations! You made it to the finish line. Be sure and submit your completion form to your foster care coordinator in order to receive training hours for this video. Thank you for your time. We hope that you have found this helpful.